So welcome again. Today I'm going to lecture briefly about the 3 chapters on contracts 8, 9, and 10. So when we're talking about contracts, there are different type of components that have to be present in a contract for it to be a contract that the courts see as a valid contract, right? Unless these 4 elements are part of a contract, you cannot really take anybody to court and say somebody didn't keep their promise based on what they said in the contract if these 4 things aren't present. So the 4 points that have to be present in a contract, and I will lecture a little bit about them afterwards, but I'm just going to be brief here with this slide. They are agreement, consideration, contractual capacity, and legality. Agreement is basically where the parties that are involved in the contract have to agree on the terms, right? And they have to state that they're agreeing, and that's usually by a verbal agreement or by signature, right? Consideration is each party that is part of the contract has to get something in return, right? If you're paying for something, you have to get some kind of service or merchandise or product or something in return, right? If there's no consideration, it's not really a contract. And again, I'll talk a little more about that. Contractual capacity, you have to have the mental capacity to understand the terms and the consequences of entering into a contract. And legality, the subject matter of the contract has to be a legal subject matter. You can't, well, you can have a contract, you can make a contract about something illegal, but that contract will be non-existent as far as when it comes to the law. There is no contract if it's illegal. Let's say you're doing a contract about a drug deal. That would be illegal, and based on the laws, that contract would be not a valid contract. All right, so again, consideration, there has to be something in it for you when you enter into a contract. It doesn't necessarily have to be money or a product. It could be a service. Think of it of an exchange of something. Somebody is giving up something and somebody is in exchange for giving up something, you're receiving something. If I'm selling my car, I'm giving up my car, but in exchange, I'm receiving money, right? Now the exchange or the value has to be legally sufficient. Consideration must be something in the value, something of value in the eye of the law. So if I sell my car and the market value of my car is $10,000 and somebody convinces me to sell it to them for $1,000 because they have such great negotiation skills, and I sell them and I agree to sell it for $1,000 or even for $10. And then I realized that I got ripped off, that I should have really asked for more money. I can't really take them to court for that because the courts do not decide whether it's a fair market value, but they only, because if you agree, you agree, but it has to be some kind of value, right? Contractual capacity, there's something, and we do actually have a discussion about this week as well. Minors have special privileges when they enter into a contract. Minors are people under the age of 18, right? Minors can disaffirm a contract or set it aside and say, or they can basically change their mind about contractual obligation. So if a minor enters into a contract and is still a minor, let's say you're 17 years old, you enter into a contract and you decide you don't really want to have this contract in your life anymore. If you're the only one who signed the contract, you can get out of it, right? Without any retaliation against you by the other party or by the legal system, right? The only thing you might have to pay for is, let's say you did something and you used up part of it, whatever you used up, you're responsible. Let's say you enter into a gym membership and you're 17 and you maybe signed a contract for a year, but after 2 months, you use the gym a little bit, but you decide you don't really want to use it. You're not using it enough. Of course, the 2 months you paid, you can't get that money back, but going forward, you don't have to pay the rest of the contract, right? There was an example in the textbook about a minor who bought a truck and changed his mind about keeping the truck, a pickup truck. And I think all they had to do was pay whatever they used up, and they would get refund of the remaining value of the car, right, of the truck. So I have a discussion about that in this weekly module. We'll talk about it briefly later. There are some type of exceptions. For example, if the minor is emancipated and it enters into a contract, they might not be able to disaffirm it, right? Ratification means actually the opposite of disaffirming. It means you're accepting the legal force to an obligation that was previously not enforceable. So let's say you're 17, you enter into a contract, and then you turn 18. Shortly after you turn 18, if you don't do anything, if you don't say, I don't want this contract anymore, that contract now becomes ratified. And now after you turned 18, and a reasonable time after that, not the day after, but maybe a couple of months after you turn 18, a few months after, if you are not disaffirming the contract, this contract now becomes a legal contract that you have to follow. You can no longer disaffirm it if you have not ratified, if you haven't done so within a reasonable time, right? Do parents have liability? Well, a lot of businesses actually ask the parents to sign the contract as well. In that case, yeah, the minor can get out of the contract, but the parent would have still legal liability to whatever they signed. If they co-signed a contract, if they say they will pay for the entire duration of the contract, the parents will still be liable, right? And a lot of businesses will not enter into a contract with a minor unless they have a legal guardian sign, right? Intoxicated persons usually do not have the mental capacity to understand the terms of a contract and the consequences of it, right? But they have to be intoxicated enough. If somebody had one beer or a glass of wine, they're not intoxicated enough not to understand the terms, right? So that in that case, the contract would still be enforceable, right? They have to be sufficiently intoxicated. If they were intoxicated enough that they did not understand the consequences of this agreement, then it could be voided, right? There is a case in the textbook about a person who was at a bar with a friend, and the friend wanted to buy that person's farmhouse, and they were drinking, and the farmhouse owner actually agreed to sell the house, and they wrote it down on a piece of paper, I think on the back of a receipt or something, that they're selling it for this amount, and they both signed it. And the next day, the owner of the farmhouse said, oh, I wasn't serious. I was drunk. I didn't really mean it. But you know, that there were some other details you will read in the textbook. In the end, he had to still sell the farmhouse. The courts decided that was a valid contract, right? He could not prove that he was drunk enough. So read that case in the textbook. It's pretty interesting. And then mentally incompetent persons, some people are mentally incompetent, but if you were mentally competent at the time you signed the contract, that contract is valid, right? If you become mentally incompetent after you sign the contract, it doesn't matter. You're still obligated to fulfill your part of the contract. If it's a contract for a service that you're paying for, you still have to pay. Of course, if it's a service that you were providing, and if you become mentally incompetent, you can't provide the service anymore, that would be a different story, right? Legality, again, contracts have to be legal. The subject matter of the contract has to be legal, and it's not always as obvious as, you know, a drug deal or something like that. Contracts to commit a crime, of course, are illegal. Usury is charging an illegal interest rate for debt, right? There's a maximum amount of interest rate that creditors can charge for debt. And that interest rate is very high. It's like something like 28%, I think, APR, right? So anybody that charges a higher interest rate than that would commit usury, and that contract would not be valid. Gambling in most states is illegal. So contracts for gambling it's illegal, that would not be a valid contract. And licensing statutes. So certain types of jobs require people to have a license to perform a job. For example, if you hire an electrician to fix some electrical lines in your house, that electrician has to be licensed, right? They have to have an electrician's license. If you hire a surgeon to perform some kind of surgery on you, that surgeon better be board certified and licensed to perform surgery, right? If they are not, that contract becomes illegal, right? And not valid, right? So be careful when you hire contractors for specific work that they are not unlicensed. If you knowingly hire unlicensed people, you might not recover if there was a breach in that contract, right? Because based on the law, no contract really exists. All right, there's something else, undue influence. It's persuasion that is less than actual force, but more than advice. So sometimes people have kind of personal power over others. This is not threatening somebody, but they are kind of dominating them emotionally or because of their position, and they kind of pressure them into signing a contract. This could be voided. This contract could be voided if it can be proven. Duress is, can be both a defense or an enforcement of a contract, depending on the circumstances. But if somebody forces you to sign a contract, that definitely can be voided if you can prove it. Another topic I wanted to address is contract performance. When a contract is executed, that means both parties have completely performed their part of the contract. Let's say you enter into a contract with a apartment complex, right? You're renting an apartment and you're leasing it for a year. And you enter into a contract. The entire time you live in that apartment, the contract is executory because you both are still performing. The landlord provides you the apartment to live, and you are making your monthly payments to the landlord to occupy that apartment. After you move out and after you get settled, the deposit and everything gets settled, that is the time the contract is executed. Until basically when the contract ends is when the contract is executed. Okay, so remember that. Until then, it's an executory contract. Some contracts need to be in writing. Not all of them need to be in writing. So here, according to the textbook, and these are the basic categories, when a contract must be in writing. So contracts involving interests in land, so any real estate contracts have to be in writing. Contracts that cannot, by their terms, be performed within 1 year after the day of formation. So when the contract is formed, when people basically sign the contract, if the work cannot be performed within 1 year, that contract has to be in writing. Let's say you're entering into a contract with a company to make you build you a house, and they cannot, and it will not be completed within a year. That has to be in writing, right? If it's a contract about collateral, like let's say you're getting a loan and putting your house up as collateral, that has to be in writing. If you're doing secondary contracts or such as co-signing a loan or something like that, or taking over the duties of somebody else to pay back a loan, that has to be in writing as well. Marriage contracts have to be in writing. Marriage is you enter into a contract when you marry. Just saying I do is not enough. You still have to sign something, right? And under the Uniform Commercial Code, contracts for the sale of goods priced at $500 or more have to be in writing. So this is not service contracts. You can have a service contract for $5,000, doesn't have to be in writing if it can be completed within a year. But if it includes sales of goods, if you're buying a car for $10,000, that has to be in writing. Another topic I wanted to cover is about assignments. Contracts can be assigned. So transferring to another all of the rights under a contract, that is an assignment, and you can review that on page 266 of your textbook. But basically, this happens. A good example of an assignment would be if you get a loan. Let's say you buy a house and you get a mortgage and with a bank, and maybe a year after you make payments to that bank, the bank has the right to receive payments from you every month, right? You make the monthly payments to that bank. They can assign the rights to another bank. They can sell the mortgage to another bank. And now the new bank has rights to receive payments from you. So rights are assigned, right? Another example of an assignment, apartment lease can be assigned unless it is specified in the contract that it may not be assigned, right? The right to live in an apartment can be assigned if the contract doesn't specify that it cannot. Delegation is transfer of duties. So somebody who has duties under a contract can assign those duties to someone else unless it is specified in the contract that duties cannot be assigned. This may happen sometimes when you get into a contract for somebody to perform work on your house or some construction work. They will hire subcontractors and assign the duties to another party, right? What's important to know is if the original person who entered into the contract is still legally responsible for completing the duties as specified in the contract. So if the subcontractor does not perform the duties, the original contractor is still responsible. It does not relieve the original party to the contract of the duties. And you can look at that on page 268, Exhibit 10.1. What can you sue for when somebody breaches the contract? When you are the non-breaching party, the other party does something wrong, you can sue for compensatory damages, consequential, punitive, and nominal. Compensatory, let me just peek ahead. Yeah, compensatory damages are those to compensate you for your losses. Let's say you hire somebody to paint your house, and that person paints your house, but messes up on one wall or one room, and you have to hire somebody else to correct that mess. And now you can sue the painter for to compensate you for the damages for the amount that you had to pay somebody else to correct what he did wrong or she did wrong, right? That's compensating you for your losses, right? You can't request the entire money to be paid back because they did part of the house. You only had to pay a little extra to fix the damages. You can't say, oh, I'm not paying you because you didn't do this room properly. If they did the entire house except for one room and you have to pay somebody else to fix that room, that's the only amount you can sue for, right? Consequential damages are those that come up because of a consequence, because of somebody breaching the contract. I'm trying to think of an example. The one I usually give is, okay, so if a plumber comes to your house and fixes some plumbing and doesn't do it properly, and there's a leak because something was not done properly, and that leak causes now your hardwood floor some damage. So although the plumber did not work on your hardwood, but as a consequence from the leak that plumber caused, your hardwood is now damaged, right? So now you can sue for, that would be consequential damages you can sue for. Sometimes between businesses, when another example would be when you have a contract with, let's say you're making, you're manufacturing products and you have a contract with another company that delivers you supplies. Let's say you're making computers and they're promising you to deliver X amount of semiconductors every month, right? And then they stop delivering it. As a consequence, you now cannot make your computers. And maybe as a consequence, you lose a deal and they go to another company that does provide them the computers, right? So you could sue them for the loss of profits that you could have made had they delivered their parts as promised. Punitive damages is not that common, actually. Those are in addition to consequential and compensatory damages that sometimes the judge might award just to give an extra slap on the hand because that party was so bad they're giving extra damages. And then nominal damages is really just a small amount where there were not really a lot of losses, but just to make a point saying, yes, this party is wrong, you're going to award $10 or something like that because somebody was at fault, but there were not a lot of damages. Mitigation of damages, if you are the non-breaching party and somebody else breaches the contract, you are legally required to mitigate the damages. In other words, to keep the damages as small as possible, right? So let's say there's a plumber that causes some damages on your plumbing that caused a leak. You can't just let the water leak and let the whole house floor get damaged, it is your legal responsibility to now turn off the water to your house, so the damages will stay smaller, as little as possible, right? All right, some other stuff that you see in contracts, arbitration agreements, those were covered actually in chapter 2. This is where you agree that you will not, you give up the right, actually, you give up the right to sue them in court if there's ever a disagreement, right? And that you will go to an arbitrator instead of going to court. I think we had an example, some links about arbitration at nursing homes. There was an article in there where people that were in nursing homes wanted to sue the nursing home because of the way they were treated, but they couldn't because there were arbitration agreements. So a lot of contracts will have arbitration agreements. And another topic that comes up in contracts is release of liability. When you release the other party of liability, if you get injured because of the because you could get injured as part of the ongoing contract. For example, if you join a gym membership, I guarantee you will sign the release of liability saying, if I get injured by my own fault, I am not, or not even, doesn't even say by your own fault. If I get injured at the gym, I will not sue them. Of course, that does not give the gym the right to be negligent and stop maintaining their equipment. If that happens, you could probably still sue them for it, right? But in general, if you accidentally drop a weight on your foot or whatever, you know, or if you work out too hard because the trainer pushed you, or you were at a workout class and you pulled a muscle or fell, whatever, that you will not hold the gym liable, right? So that's release of liability. All right, that is it for the lecture on 3 chapters, actually. I'm going to stop the recording now, and then you can ask questions.